Welcome to another episode of The Velvet Hammer.
And here we go.
Yeah. So Monday, beautiful day. So sunny.
It is.
Come to office.
Yes.
And guess what?
You get pooped on?
Yeah, pooped on by Amazon. Amazon poop.
It is like bird poop. It drops out of the sky. It goes splat. It's totally ugly, stinky, and amusing all at the same time.
Okay. What I call disclosure. We do not have an anti-disparagement agreement with respect to this case that we're going to talk about with Amazon. And why don't you tell us what we're talking about today, Karen?
Okay, so they sent us poo-poo, as I already said. We served in a... Well, okay, start at the beginning. A different lawyer had this case and realized that they were being taken advantage of and brought it to us to handle. So we got involved, and Amazon was very unhappy with that.
They were very unhappy with it.
And we filed an amended complaint, which they were very
unhappy
And
with.
then we served discovery on them.
So unhappy.
Very much so unhappy. The case had been going on for for a year at least before we got involved.
Yes.
We turned everything around. So then they got the discovery, and then what did they do?
They didn't give us it. They gave us 11 pages.
No. They asked for a continuance.
Oh, wait, that's right. They asked for one extension, and we were courteous.
And they then did what did they do after the first extension?
They asked for a second extension.
The second, because they're working so hard on this discovery. I mean, Amazon has layers and layers and layers of administration. They have about 1,000 lawyers on the case, in-house and out-house. And what do we get?
Bubkus.
A poo-poo.
Bubkus. I mean, we got nothing, man.
It's so bad. And I know you guys don't believe us. So here we go. Like, this is just, we should start having a star system for who can do good or who can't. I mean, this would be a minus. Okay. So question number 1, tell us who your experts are. Now, there are new court rules that say if you have an expert or any information, you can't say, well, we'll give it to you when the case schedule, when the time that the judge sets is right. There is no time that the judge set that's right for discovery other than timely. So it says, identify each person you expect to testify at trial as an expert. Okay, answer.
Amazon has not yet determined which experts it expects to testify at trial. If and when such experts are retained, appropriate disclosure in accordance with the case management order will be provided.
Okay. Do they have experts?
I don't think they have experts.
They could have experts.
They could have experts. I don't know. Well, the case is so old. For them to say they don't have experts.
This says, no, but they don't say that. They say they've not determined which experts will be testifying at trial.
That means they have them.
Thank you.
And they just don't want to tell us.
They're not going to tell us until the case management schedule says, but that's against the rule.
That's not the rule.
Okay.
Rule breakers.
Okay, so when they're bad and they do stuff like this, who follows up?
Kristen does, and then I do.
Wait, you got to do the Ruthless Mo thing.
Oh, it's...
Okay. If when we follow up with this, who will be following up?
Ruthless Mo. Ruthless Mo will be following up.
And what will Ruthless Mo be doing?
Be ruthless.
Okay, but you got to show how ruthless you are.
I'm going to tell him, give me my discovery. Give me my documents. I want it, and I want it now. That's what I'm going to do.
He is, too. All right. It's going to be worse than that, though.
It is going to be worse than that. I'm in a good mood. It's sunny outside, and you're asking Ruthless Mo to come out. It's going to take a little bit. But I got to read more of these, then I'll get angry.
All right. Number 2, identify and describe all the facts upon which your denial of liability is based. Okay. Let's stop here. Now, liability means cause of the incident. Okay.
Yeah.
I think that the Amazon driver was going the wrong way down the highway.
Yes.
Okay.
Yes.
Right?
Yes.
There shouldn't be too much dispute in that. Going down the wrong way of the highway.
Yes.
All right. There's a little bit more because there's also vicarious liability. We just asked for liability. Okay. So remember, their driver was going which way down the highway?
Wrong way?
The wrong way down the
Yes.
highway. And so it should be pretty simple, right?
Yes.
Okay.
But it's not simple. There is a complete paragraph of
No, you got to read it because it's so bad.
Amazon.
As fast as you can.
Amazon objects to this interrogatory as it is overbroad, unduly burdensome, and not reasonably calculated to lead to the discovery of admissible evidence. This interrogatory impersonally seeks to obtain impressions, conclusions, and opinions of counsel, as it seeks information protected by the attorney-client privilege, the work product doctrine, discovery exemptions afforded consulting experts, trial preparation materials, and or information afforded any other applicable protection or privilege. Plaintiff is referred to the general denials in Amazon's answer to plaintiff's amended complaint and to the affirmative allegations and or affirmative defenses set forth therein. Amazon further objects to the extent this interrogatory's premature discovery is ongoing and calls for investigation up to and including the time of trial, subject to
Okay.
and without waiving
This isn't
objections.
First of all, you did that really good. Okay.
You
now,
like that?
so they make this huge objection.
Yes,
And now they're going to answer. Are they?
kind of. This is so silly. Amazon responds that it did not employ the defendant. The defendant was an independent contractor under the terms of his agreement with Amazon. Amazon did not employ or control any person involved in the accident, nor was Amazon present at the scene, nor does Amazon have any personal knowledge of the accident. Any damages sustained by plaintiff as a result of plaintiff's own contributory negligence and or the unforeseen, superseding, intervening acts of defendant over whom Amazon had no control. Additional affirmative defenses pled in the case other than superseding negligence and apportionment were pled to preserve them on the basis that facts would come in light as an investigation and the discovery process gives rise to the basis of such affirmative defenses or affirmative allegations. In the absence of completion of pretrial discovery and additional information that should be revealed by discovery proceedings, including depositions. Amazon does not possess sufficient information to fully respond to this interrogatory at this time. Amazon reserves the right to supplement its response to this interrogatory.
I think you're ready to do a side job as an auctioneer.
I think so. Okay.
Sold.
You guys,
$5.
There
Sold $5.
there was nothing said in this whole answer.
No,
What?
no, there wasn't.
Okay.
What? Wait, Mike. What happened in this accident?
I don't know.
I just told you. We told you.
Oh, the guy was driving the wrong way down the freeway. Yes,
Okay.
you did say that.
Right. I mean, yeah.
Yeah,
That's an
don't-
easy one.
I'm confused as well. I feel like if you're driving the wrong way down the freeway, we're not just talking about like a one-way alley or something like that. We're talking about the freeway.
Okay. We go to interrogatory number 3. And now what they're going to do, see, remember that answer we just read?
Yeah.
They're
Yes.
going to invoke it. So all
Are they
the,
wizards?
Like the next
Yes.
the next series of questions will just say, "Hey, see our answer to
Yeah,
that
exactly.
one that we
They're
just
just going to
did."
keep saying, go back to that long answer that meant nothing.
So we ask number 3. We ask if someone else is involved, and they say, "Hey, go back." We invoke it. They say, "Specify all facts upon which your affirmative defenses are based." They invoke it. Okay. Oh my God.
Okay. Why, okay, I'm going to have a discovery conference with these guys. And I'm going to tell these lawyers, why are you wasting my time? Now I'm getting angry. I am reading this. This is an entire waste of my time. Entire waste of my time. Why did they do this? Why did they do this?
This is why Amazon lawyers say that Mo is not cordial.
Of course.
This is an entire waste of my time.
It's
Why are
entire-
you making me read these words? This is
After 2 requests
These
for
are-
continuances.
who does
answer.
this? What kind of professional drafts responses like this? This is an entire waste of my time. This is an entire waste of resources. This is worse. The denials here, these people are untethered from truth, from reality. They're irrational.
He's going off.
No, I am. This is pissing me off because. Okay, all right,
Stop.
all right,
All right. Ruthless Mo, I backed you off.
okay.
Okay. Interrogatory number 5. This is one that the courts have drawn up. This language, by the way, is all kind of form language, the questions. And this one is a form question. It's basically, regardless of whether you agree that you're faulted or not, tell us identify each and every policy of insurance maintained by you that may apply to the claims or may be liable to satisfy or any part of the judgment. And that includes the name of who's insured, the entity who issues a policy, the policy limits, the policy periods, any exclusions, any decisions affecting coverage, and go on and on and on. Now, again, this is basically a court-based request.
Like, do you have insurance?
Do you have insurance?
Do you have insurance?
Not a trick question.
And just to clarify for me, this is the insurance that Amazon has, not their third party.
Yeah, these are responses to Amazon.
Just Amazon.
This is only there's a whole separate set
of
to the
attorneys that
other
are
program.
that are dealing with the other side. Okay.
All right. Okay.
Amazon objects to this interlocutory on grounds that is overly broad and unduly burdensome, seeks irrelevant information, and is not reasonably calculated to lead to the discovery of admissible evidence. Given the breadth and scope of Amazon's insurance program and the circumstances of this accident, rendering this interrogatory excessive given the facts and claims in this litigation. Amazon further objects to this interrogatory on the basis that it seeks sensitive and confidential proprietary business information.
Yeah. Sensitive and proprietary business information as to its insurance.
Sensitive, like emotional? No, okay.
They might cry.
I think they are crying.
Additionally, Amazon objects to this interrogatory misleading, assumes facts not in evidence, as Amazon did not employ or control any person involved in the accident, nor was Amazon present at the scene, nor does Amazon have any personal knowledge of the accident. Further, Amazon objects to this interrogatory to the extent it requires Amazon to make a determination as to available insurance coverage. Subject to.
Okay, so
Wait, they just said that they don't have any awareness of the accident?
Yeah. Yeah.
because they weren't present at the scene.
They were present at the scene. You know how? They're
tracking those things.
digitally present at the scene,
track,
Mike.
They track all those. I mean, because it's a Amazon branded van that they were driving, right?
No, this is
Not
different.
this one?
This is a flex program.
This is the Flex program.
Yeah, but they still have their little phone that they have to carry
They got their
around,
little
so they
app.
know where they are. They know what they're doing,
All right. Okay.
or I assume.
All right. We're not going to we don't have to say who their insurance companies are.
No, I won't say
Okay. However, it says after laying out a certain amount of coverage, it says
Well, it says that
after laying out a lot of how much their limits are, it says
the part where it says any policy beyond this scope, beyond this is beyond that part. Any policy beyond this is beyond a reasonable scope of the present case and therefore not relevant here, given the nature of the facts and claims at issue in this litigation. If plaintiff's counsel believes disclosure of higher levels of the insurance tower is necessary in this case, counsel can schedule a CR26I conference.
if we think that we're going to get a lot of money, then they might have to give us more information.
More insurance. So they're basically telling you how much the claim is worth.
Okay.
They think it's worth.
Then they have to sign a certification.
Why did they do that? Why do they have to sign that one and not the other ones?
Well, they're supposed to sign all their objections, supposedly. That was the old school.
Yeah.
But in this one, they're supposed to write down the name and sign it of who is making the special certification because, shocker, we've had so many cases where they've lied about how much insurance is available.
Oh, yeah,
Not
and they've
they,
been sanctioned.
not Amazon.
Yeah, not Amazon.
Other people. So for all of these defendants, we always put the special certification. This is not a special Amazon provision.
Okay. All right. So we've got two.
And we already talked about the sanctions orders.
We did.
From the case where they signed certification and lo and behold, there was way more insurance.
Okay. So now I want to talk to you about and get some insight. We have these two particular interrogatories that they have not really responded to. What's the process of going through and scheduling a 26I conference and talking to them, and how would you approach that conference with answers like that?
Well, I still want to go through all these.
Oh,
other
do you want to go
answers.
through all of them?
Okay, wait.
Well, pick
okay,
another
wait.
one because
They're very similar.
they're all very similar. All of them tell us to basically go pound sand.
But in addition to the interrogatories, of which again, none of them
And an interrogatory is
A question.
okay, a question. That's all.
Okay, but they include the discovery request includes request for production, meaning
Yes.
so we're asking for documents.
Yes.
So, let's see, which one do I really like here? I think, well, they don't like any of them.
None of them.
They're all the same objections. So pick whatever your favorite question is and read it to us. Tell me which number.
I would say. Okay.
Which one?
I'm looking. I would say request for production number 14.
Oh my gosh, you really went down.
Yeah, because I think that's an important one.
Okay. Request for production number 14. All documents related to the Amazon Flex program, including policies, procedures, and guidelines applicable to drivers.
Okay.
That's the shortest objection of all of them.
Yeah.
Okay, go ahead.
Well, just for our sake, the Flex program is a program where you can take your personal car and then you can enter into an agreement with Amazon and use your personal car to deliver Amazon packages.
It's like being an Uber.
And are you an independent contractor when you're doing that?
By contract, you are.
Who then? So you individually are. You're not under the umbrella of a third-party company.
No, you're not. You're an individual contracting with Amazon. Now, Karen can can educate you right now about vicarious liability very quickly.
If Amazon controls you while you're doing the job enough, then you are in a relationship with Amazon.
That was my question.
Yeah.
Is you're actually working for Amazon?
Happens all the time in our Uber cases and our Lyft cases.
It's the same with
Yes.
Uber and Lyft. They try to play that same game, and they've lost that several times now, right?
So what we're asking for is documents related to that program.
Yeah.
And policies and procedures and guidelines that Amazon imposes on the drivers. I mean, it's
they're
a
objecting
national
to that?
Well, yeah, they're objecting to it. They're saying Amazon objects to this request as it is overbroad, as it is vague, ambiguous, overly broad, unduly burdensome, unlimited in temporal or geographical scope, is not reasonably calculated to lead to the discovery of admissible evidence, seeks information that is completely irrelevant to the subject of the incident, and is completely incommensurate with principles of proportionality and the needs of the parties in this case. Amazon further objects on the basis it seeks documents that are confidential and are proprietary regarding its business that have no material bearing on the issues of liability or damages in this litigation. Amazon also objects to the extent this request seeks information and or documents protected from disclosure by the attorney-client privilege, the work product doctrine, or any other applicable protection.
Yeah, that's a lot of words, and I'm just going to say no, because all of that that I heard is them trying to say our policies don't affect us at all. But how can they not when they're saying that person's not an employee?
They do. They're just being obstructionists.
Yeah, they're just trying to stand in the way and slow everything down, so it takes longer and longer.
This is why I got angry earlier and she had to honk the horn.
Okay.
Yeah.
Okay, so I want to some education.
I'm gonna lead this.
Okay, all right.
It was my idea. Dang it.
Okay, sorry. Okay, I thought I was trying to
Back
transition.
off!
Okay, I'll back off.
Okay. We are now going to role play.
Oh, we are?
Yes.
I love it.
Yes, we are. I sent a letter this morning to Amazon that said, "Dear Amazon," did you send my letter?
No, I'm going to see the letter.
I said, "Dear," okay, you can read my letter,
I want to read the letter.
and then we'll go from there.
Okay. And you sent him an Amazon in response to this?
I sent a note, an email
Okay. Hold on.
to Mr. I can't remember.
Oh. Dear Counsel, our team just took a vote and agreed that these are some of the worst, incomplete, over-objected to, non-responsive answers to discovery we've seen. Please sign the verification page specifically regarding insurance. P.S. Disclosure of all insurance means all. Mohammadi will be taking the lead in shepherding you properly through the discovery process. Oh, you've tasked me already, Karen. Okay, all right.
That was
I imagine you in a Indiana Jones outfit with the whip.
Yes. Bum, ba, ba-da, bum, ba-da, ba, ba, dum, dum, da-da, da-da.
So they already know it's coming. If they've done
Well,
their
they
due
have
diligence.
to because you just got done working with them.
Oh,
Yeah.
well, okay, here's the fun part. They don't know what's coming on Friday, and this is not going to be published until after. They've filed a motion for a protective order. And the objection I'm going to file for the judge to enter the protective order is going to be a doozy. I've been working on it. It's going to be a big one.
Okay.
That's going to be fun.
Stay back on track.
Okay, I'm back on track.
Role playing.
I'm role playing. Yes. Okay.
All right.
Back on track.
So we're going to have our first discovery conference in this case.
Yeah.
It's going to be Mr. Hamoudi
Yeah.
meet Amazon.
Yeah. Yeah.
I'm going to be the Amazon.
Yeah.
It's going to be in person?
No, they never want to do in person.
Yeah.
Oh, first of all, what are you going to ask them
What do you mean? What
before we set up the call? What do we want to do?
want to record this? Hey, do you mind if we record the 26i conference?
Yeah, no, that's not going to happen.
Okay. Well, we're going to move to ask the judge to record it.
On what basis?
Judicial efficiency, transparency, and the fact that you have obstructed discovery in another case. I'm going to attach the orders with the judge.
Well, we disagree.
Okay, great.
Fine.
We'll go to that.
Okay, fine.
All
I
right.
went to Harvard.
Oh, Harvard?
Yes.
Harvard? You went to Harvard?
Go ahead. Keep going.
Okay. How about them apples? You went to Harvard. When are we going to get our discovery?
Did I tell you I went to Harvard?
No, you did tell me you went to Harvard.
Yeah, I want to. Yeah, I just want to make sure you knew that.
Okay. Well, since you went to Harvard and you took probably civil procedure, you probably understood in civil procedure, do you have an obligation to give me discovery? So why haven't you given me discovery?
We did give you discovery.
Okay, let me ask you another question. Do you know what happened to my client? Do you know how much injuries they sustained? Are you aware of that?
I'm really sorry that the defendant driver hit them, but we have nothing to do with them.
Okay.
By the way, did you know that I went to Harvard?
All right. You say that one more time, all right?
Are you threatening me, Mr. Hamoudi?
If you say that one more time,
You are being uncollegial.
if you say that one more time, I'm going to talk to you about where I went to college.
I don't care about where you went to college. You are nothing. You are a peon. I represent Amazon, and I went to Harvard. Stop breaking character.
It's hard because
It's hard because you just
hard
keep
to
saying
break
you went to
character.
Harvard over and over.
you keep saying Harvard. But I just have a simple question. Are you going to give me the documents that I need to prove that your client is liable for this collision? Are you going to do that?
We've already given you 11 pages of documents.
Okay.
And if you want the rest, we need a protective order because everything we do is top secret. You don't understand. The whole balance of the world relies upon Amazon. We are so essential to every single thing in the whole wide world. And did I tell you that I went to Harvard?
Yeah, you told me you went to Harvard. And
Anyway, we need a protective order, and we'd like you to agree to that. And all that it'll say is that we're going to show you some documents, and then we're going to take them away, and you got to pretend they never existed and never tell anybody about them. And we're going to hide them back where they came from. We might destroy them, but we might also, hide them. And they should never see the light of day. But we really don't want to give them to you because, did you go to Harvard? I didn't think so. I mean, I don't know if we can do the pinky swear code.
No, but I went to a non-ABA accredited school. That's where I went.
Oh, my God.
I can tell you that I bartended at nights when I went.
Hold on just
went
a
to
second.
school. Yeah.
Hold just a second.
Yeah.
Rebecca, this guy did not go to Harvard. Can you believe it? I mean, what the heck? I don't even know how to communicate with them. Maybe, didn't they say to do that on like a 5th grade level? Mr. Hamoudi, let me repeat. We are very important.
Yeah.
These documents are very, very top secret. Top secret, like I Spy with my little eye.
Yeah.
You cannot get them because you did not go to Harvard.
I'm going to destroy your client. That's it.
Mr. Hammoudi, that's not very polite.
I know. It's not, because I'm done being polite.
You are mean, Mr.
Mr. Hoodie, yes, I am done. I am finished. I am finished with you. Okay? I am going to extract accountability out of your client, one way or another. And that's what I'm going to do.
I don't
And
know.
then
Mr. Hammoudi, that's not how we act in Harvard.
But I don't care.
I need you to respect me.
I am not a
I am a
Harvard
big, bad lawyer,
I am-
way bigger than you. And see, there are 20 lawyers over here sitting here, and we're all taking notes of your behavior.
I think we need to record this conference then.
Yeah, I was going to say, if they allowed it to be recorded, they'd have a lot of
And had
proof.
you agreed in the first place, you would have had really good evidence to tell this judge.
All right, this meeting has to be concluded because you're mad and mean, and we don't play that.
That's just the way I am. That's literally kind of how it goes.
I
These
believe you.
conferences.
I'm sure. I'm just curious. Can you ask them if it's policy for their drivers to go the wrong way on the freeway?
Yeah, I mean, you could ask them that. They're just not going to answer it.
Oh, I'm
They're
sure.
going to say they're not their drivers.
The way they've designed,
they don't know.
The way they've designed this is that you have Amazon and you have lawyers that work for Amazon. Okay, then lawyers that work for Amazon hire law firms. Okay, to do their work, and then what they do is these lawyers are not. They have no power.
Yeah.
They go to lawyers for Amazon. We have a discovery conference. It's strip matter firm again, and what do we do? And they go, you do nothing. So they come in and go, my hands are tied. I can't do anything. So what we're going to do is we're going to reveal that dynamic to the judge, that these guys are nothing. They have no power. They have no say. And what you're dealing with is a bunch of lawyers sitting down here on Terry Avenue in Seattle, too cowardly to show up in the court and step up and defend their client.
Ruthless Mo, go away.
Okay, I'm going away.
Sorry, I'm winding him up.
But you wind me up. But Karen, it's the truth, Karen.
Okay.
It's the truth. It's the
gone.
truth.
It's gone.
But you summoned him, and then now you're saying go back.
His eyes got really dark when he was talking to me. He really hated
Oh, you were firing me.
when
up.
I talked to him in little boy language.
But the thing is that she was like playing the part, and then I love her so much, like I can't get angry at her.
Yeah.
did,
And
though.
so
He
I
did
just
a
was like
little bit.
starting to get a little, and I was like, "What is she doing?"
She
She's
did
really-
good by just bringing up Harvard that many times because that
man.
can wind you up for sure.
That winds me up for sure.
Although I am very proud of Harvard right now.
Oh, I that's the thing I was going to say.
Politically.
It's it's a play on the fact that a lot of hoity-toity lawyers do that, but really, Harvard does good work.
They wouldn't bow to the king, and so I'm happy with them. So maybe I should have said Yale.
Yeah.
We'll do that next
Next
time.
time, say Yale. Say Yale. Don't say Harvard.
Anyway, this is the story of our lives.
Yeah.
Going about our way, just trying to do our job.
Just asking questions and getting the same answer over and over again.
After 2 requests, because, they needed more time to write these objections.
Of course.
They didn't.
Well, because they have to have meetings with the other firms that they've hired so that they can tell them not to answer.
All right.
Okay, we're done.
Okay.
Yes.
Bye.
Well, that's all for today.
Until next time.